open up the hearing for SB 108 and hear from our prime sponsor. Welcome, Senator.
Good morning. Welcome, committee members. For the record, my name is Senator Howard Pearl from District 17. I reside in the town of Loudon. I am here today to introduce Senate Bill 108. This bill transfers specific regulatory and adjudicative responsibilities from Public Utilities Commission to the Department of Energy, including prohibiting unauthorized telecommunications service provisions, protecting ratepayer communication preferences, and refining net energy metering, assessment, complaint, investigation, and aggregation procedures. I will tell you, I put this bill in on behalf of the Department of Energy, and their general counsel, Dave Shulock, is here, and he's going to go over the details of the bill. There are some recommended changes to it, some deletions and some language amendments that Mr. Shulock brought to my attention. So I'm going to ask you to bring him up next and let him explain the bill and the changes that they would like to make. Thank you.
All right. Thank you, Senator. And who did you want to come up?
Dave Shulock.
Dave, do you mind coming up?
Good morning, Senator Avart and members of the committee. My name is David Shulock. I'm the General Counsel at the Department of Energy, and I wanted to thank Senator Pearl for bringing this bill forward for us, and Senator Avart and Senator Waters for co-sponsoring it. Much appreciated.
You're welcome.
Okay. So, as Senator Pearl said, there are some recommended changes to this bill. After the language of the bill was published, we had some discussions with industry and some stakeholders. We tested out some of the language that we thought was very clear, and they didn't quite agree. So we have some requested changes, which I'll go through as we go through the bill, if that's okay.
Yes, absolutely.
Okay. All right.
First of all, what does it do for the public?
So probably best described if we go through each section of what the bill does, because it is sort of a mishmash of a bunch of different statutory provisions.
Is that a legal term?
So yeah, that's the first question. Is that a legal term?
Yeah, mishmash, yes.
Right.
So Section 1 of the bill has to do with something called slamming, and slamming is when a competitive provider changes your service without your permission. Okay? Section 1 would have moved the enforcement of that provision from the department, from the commission to the department. We're now asking that that section be deleted and that the enforcement of slamming remain with the commission. Okay.
So lines 1 through 6?
8.
1 through 8, yes.
8.
Okay. Section 2 has to do with ratepayer protection, which is centered at the department. This provision in particular allows one of the agencies to develop rules to determine how customers let their competitive providers know how to contact them and provide them with information. And we just believe that that's more properly at the department, since consumer protection is centered there, right? The rules for that are actually already developed in the PUC 2000 rules, and we're going through a process now to divide those rules between the two agencies. And so with this statutory change, the rules relating to customer communication for competitive suppliers would go to the department. They'd be in the department's rules.
So no changes?
No changes. Section 3, the first two sections, 1 and 1A, contain some antiquated language having to do with a cap on the amount of megawatts that could be net metered in the state of New Hampshire. Originally, there was a 50 megawatt limit on the amount of net metering, and now appears the state wants as much as possible. And so that cap has been surpassed, it's antiquated, and we're just asking that the language related to that be removed. Okay? And then the second section has to do with disclosure of terms and pricing for community power aggregations. We originally thought that that was more appropriately located at the department. We're told otherwise, and we're asking that lines 19 through 28 be removed from the bill.
Page 2.
Page 2. Yeah.
Max, you're getting all this, right? Yeah.
So section 4, which begins page 2, line 29, and goes through page 3, line 11, has to do with the department's assessment of utilities and other entities for the costs of the department, the Public Utilities Commission, and the Office of Consumer Advocate. Those three agencies are funded by a special assessment on utilities, not by the general fund. And we found the need to clarify how that assessment works for some folks. So, and the way that it has worked is companies are assessed at the beginning of a fiscal year. That assessment is calculated for everybody because everybody pays their share. And some companies who leave the state in the middle of the year have assumed that when they leave, they no longer owe an assessment, but that's not quite right. So once they're assessed, they're responsible for that assessment for the entire year. And so we've asked for some clarifying language on that. When we tested the language, we found that people didn't think that the language we chose was clear enough. And so we're going to ask for a small change to this language on lines 6 and 7.
On page 3?
Page 3, yes. Yeah. We'd like to strike the words flat fee or all 4 quarterly payments as applicable and replace that with the words amount assessed for that fiscal year. And as it turns out, that's easier for people to understand.
So Max, after entire, it's the amount assessed after, you got that? Okay.
Sections 5 through 10 modify the complaint procedure. So prior to the reorganization of the Public Utilities Commission and the creation of the department, complaints were handled just by the Public Utilities Commission. When that reorganization occurred, the handling of complaints was split, right? So complaints were filed at the department, not at the commission, and then were, are investigated by the department. And we try and work things out between the complainant and the utility, right? And we sort out what's really a problem, what's not a problem, what we can get resolved, we get resolved. And then it goes to the commission, okay? Now, in that process, we've gotten 2 complaints, right? One is that it takes us a long time sometimes to get through the complaint process. The other is that people have to file a second formal petition at the PUC to invoke the PUC's jurisdiction. That makes it quite hard on especially residential ratepayers, individuals, although businesses have complained about that too because it costs them money to do a second complaint. So essentially what we're proposing with this section is to transfer the complaint from the department to the commission so that the commission can then just open up a docket. They'd issue an order of notice on it, and that individual ratepayer wouldn't have to go through the rigmarole of filing a new petition over there to get a hearing, right? It's just really to make it easier on people.
How does that work, the transfer?
Well, we'll have to work that out with the PUC. But most likely we'll sit down with them, we'll find out from them what essential characteristics they would need in a complaint, right? We'd work that into our rules so that complaints are filed in that form. And then we would begin our work of investigating and working with the parties to resolve things, at the end of which we would write a report, right? With our view of what complaints are legitimate, which ones can and can't be resolved. And then we would take that packet and send it to the Public Utilities Commission, and they would open their proceeding based on that report. Right?
Okay.
Okay. Then the other thing that this makes clear is that there are some adjudicated matters that don't go to the PUC at all. They remain with the department, right? Because when the department was created, we took staff and responsibilities from both the PUC and the Office of Strategic Initiatives. And that office handles a lot of federal programs, and there can be complaints associated with those federal programs that the Public Utilities Commission has nothing to do with. For instance, if there might be a person who accepts weatherization funds to have insulation put underneath their siding, and their siding might be damaged in that process. And if they don't get resolution at the contractor level, they go to the Community Action Agency. If they don't get resolution at the Community Action Agency, they come to the department, right? And then it has to be litigated. And the Public Utilities Commission really has no say in that. And so we will also have to develop our own adjudicative processes at the agency level, right? And so some of the changes here allow for that to happen. Which takes us to the last section, which is section 11. And there is a typographical error in there that led to a summarization of the section, and it actually refers to the wrong statutory section. Right? What we wanted to have repealed was RSA 362A9-18, so there should be a Roman numeral X in front of that 8, making it an 18, and that would be relative to that same net metering cap that is now expired, right? And not relative to time-based net energy tariffs.
So it's just the Roman numeral.
Well, and also the summary, yeah.
Okay.
That's it.
Clear as mud.
Okay.
Any questions?
David, did you mention the change you wanted on the beginning on line 37 of page 3?
I did not. Thank you very much.
Skip by that
Yeah.
one.
So in that section dealing with complaints, on page 3, line 37, going over onto page 4, line 1, we would like to delete the words "of law, franchise, or order," and have the sentence refer just to the violation charged in the complaint.
Repeat that one more time, please.
We would like to delete the words "of law, franchise, or order," which would leave the sentence referring to the violation charged in the complaint. Okay. Okay, thank you.
Any further questions?
Another thing I wanted to mention, we did talk with industry. The department is aware that NECTA would like to add some language to the complaint proceeding. We've reviewed the language. It's fully consistent with what the department intended, and we're okay with the addition of that language.
So more language?
Yes, but I'll let NECTA describe that.
Okay. Before you go, Max, I'm gonna put you to the test. Can you just kind of go over the quick changes real quick?
Yes.
deleting lines 1 through 8.
Yep.
Asking that the language related to net metering cap be removed. Is that correct?
Yeah, that's,
Or asking that lines 19 through 28 be removed.
yes. Yeah.
Page 2. Yes.
Asking lines 6 through 7, strike the word flat fee and say amount assessed for that fiscal year.
Correct.
37-1, replace with the violation charge and complaint.
Of law and,
So that's page 3, line 37, and page 4, line 1. You'd be removing the words "of law, franchise, or order." Yeah.
And saying refer just to the violation charge and complaint.
That's right.
And then add at the Roman numeral X in section 11 and correct the summary.
Right, so it should read RSA 362A:9, Roman numeral 18. Okay? And the summary should be relative to the net metering cap.
but thank you.
Appreciate it. Thank you for your testimony.
Thank you very much for your time. Appreciate it.
Yes.
We have Max to put down the shade, because when the sun comes out, it's white.
This one too, Max.
Yeah.
Thank you.
In the meantime, we'll have the Office of Consumer Advocate come on up. Mr. Crease.
Good morning, Mr. Chairman. I'm Donald Crease, the consumer advocate. My job is to represent the interests of residential utility customers pursuant to RSA 363-28. Part of my motivation in testifying today is to use an excuse to make my first appearance before this committee in this legislative session, to say hello to my friend Senator Rosenwald, who I'm not used to seeing in this committee. I hope she feels welcome. I'm excited to see her here. And
You're very
to,
welcome. Yes, you are.
I want to just let the commission know generally that I am in support of House Bill 535. Back years ago when I was general counsel to the Public Utilities Commission, I used to testify at your counterpart committee in the other body quite frequently, and there was a representative there named Jim Garrity, who now serves on my advisory board. And what Representative Garrity used to say to me all the time was, anything that increases the authority of the PUC, I oppose. And in that spirit, I say to you now, anything that clarifies the respective authorities of the PUC and the Department of Energy, I support. Because the result of the enabling legislation that created the Department of Energy almost 5 years ago, and as you recall, that happened by the budget trailer bill. That was a rather hastily compiled set of legislative reforms that were really important, and it was fairly well understood at the time, I think, by everybody involved, that the statutes would need to be refined based on experience, and we now have 4.5, almost 5 years of experience, and so it's logical that you would see a bill like this that tries to make much more clear to the public where to go when you have a problem with some entity that is subject to either the jurisdiction of the PUC or the jurisdiction of the Department of Energy, or quite often both. I asked a sympathetic member of the House to introduce a bill in that body, House Bill 535, that also proposed certain changes to the respective jurisdictions of the agencies. In the world I wish I lived in, there would have been collaboration between the Department of Energy and us around a comprehensive and I guess consensus set of reforms to their respective jurisdictions of the two agencies. And I have a lot of opinions about this because, as I said, I used to be general counsel of the PUC, and I've been consumer advocate for almost 9 years. So there is really nobody except the Department of Energy, really, who appears in more PUC proceedings than me. And frankly, much of the way energy regulation and utility regulation is proceeding in New Hampshire right now is broken and needs some comprehensive fixes. This bill does some good work, and I'm pleased to support it. I'm still a little concerned about the muddle that arises when a consumer, in particular a ratepayer, a residential ratepayer, is aggrieved by something their utility has either done or not done, and then wants to complain about it. Because what you're really positing here, and this is sort of the way it goes now, is a triple gauntlet, right? You need to call the Consumer Services Division of the PUC, and you need to work with their case managers there, and they're usually quite helpful. In fact, as far as I know, they're always quite helpful. But some customers aren't satisfied, and then under the language of this bill, I'm looking at Section 5 of the bill, and Section 6, and Section 7, Section 8, and especially Section 9, you then have a second step that you have to undertake if you're unhappy with a department. You basically have to say, well, I didn't like what Consumer Services did, so now I want to institute a formal complaint. And then, as Mr. Shulek just explained to you, there's sort of a quasi-formal adjudicative process that goes on inside the department. And then if you don't like what the department did or didn't do, then if what you are proposing is subject to the jurisdiction of the PUC, it is at that point that you then can take step 3 to actually take your complaint to the Public Utilities Commission. That's a big ask when it comes to residential ratepayers. Now, I just want to state my understanding that at the beginning of Section 5, when it says any person may make a formal complaint, we at the Office of the Consumer Advocate think of ourselves as a person, right? Our office, we believe, is enabled or authorized to make complaints if we see the necessity of doing that. And I just want to make clear to the committee that that is our interpretation of the bill. And if anybody disagrees, I hope they will step forward and say that. So those are some concerns I have about the bill. But overall, I think it's an excellent idea. And I think that, that it should be maybe workshopped a little bit and then reported out of committee, ought to pass, and then sent over to the other body. I think that's all I have to say, other than to thank you for listening to me and to say that I'd be happy to answer any questions.
Senator Rosenwald.
Thank you, Mr. Chairman. So this 3-step process described in sections 5, 6, 7, 8, and 9, how long do you think it would take a residential ratepayer to go through all those three processes?
I think much turns on the second step and how long the department takes to conduct its process. All of these things, there's no time goalposts in the bill, and I don't think there should be necessarily, because some things are very easily and expeditiously resolved. Frankly, some complaints just aren't meritorious. A lot of people are unhappy with their utilities because they don't like paying utility bills, or they don't like the terms of service that are in the utilities tariffs. And you know, you will the end result of a process like that will be an unhappy customer, but sometimes the answer has to make the customer unhappy. So what you want in a situation like that is a swift answer that people can act on, even if they don't like the answer. Because if they don't like the ultimate answer, there's a fourth step, of course. You can seek appellate review before the New Hampshire Supreme Court, or you can come here and ask you folks to adopt a bill that changes what the law says about what utilities are allowed to do. So I don't have a good answer for you, Senator, about how long this can take. I think it could be anywhere from a few weeks to, I don't know, a year even.
Any follow-ups? Thank you very much.
Thank you.
Vice Chair.
All right, next we'll call up Maura Weston from NECTA.
Good morning, Mr. Chairman, members of the committee.
Good morning.
My name is Maura Weston, and I'm here this morning on behalf of the New England Connectivity and Telecommunications Association. Thank you for the opportunity to testify. I signed in opposition to the bill as drafted. However, as Attorney Schulach mentioned, we've been in conversations with the department, and we are just seeking a couple of clarifications. Basically, we think that some clarifications are necessary so that we know precisely which entities are assessed by the Department of Energy and that certain consumer complaints remain under the jurisdiction of the Department of Justice and under the Consumer Protection Act. In Section 4 specifically, our proposed amendment would clarify that this provision is only applicable to entities that are subject to the assessment statutes. But we think that the clarification is necessary to ensure that only entities currently subject to assessment continue to be subject to this provision. If this language is not included, we're concerned that registered businesses of NECTA members not under the jurisdiction of the department or the commission could become subject to assessment. For example, a home security company. Our second clarification that we're seeking is in Part 6 of the bill. This would clarify that with the expansion of the complaint authority in Part 5 to include any entity under the jurisdiction of the department or commission, this would only apply to the existing authority. So, for example, our members are subject to certain statutes, for example, water crossings, pole attachments, dig safe, etc. So that would continue to be subject to the jurisdiction of the department or commission. However, complaints regarding, for example, VoIP providers, IP-enabled services, etc., would remain under the jurisdiction of the DOJ's consumer protection statutes. We have red line language that we've shared with the department, and we're happy to share that with the committee. I'm also happy to answer questions if I'm able to. Thank you.
Thank you. Yeah, if you have copies of that language, please give it to us so that we can consider putting it in. I know the department had indicated they didn't have any concerns with your edits, so we'll certainly consider that.
Thank you very much.
Questions from the committee? All right.
I appreciate it.
Thank you for your testimony. Dina Dennis from Community Power.
Good morning, Vice Chairman Pearl and members of the committee. I'm Dina Dennis. I'm Director of Regulatory and Legislative Affairs with the Community Power Coalition of New Hampshire. The Community Power Coalition is a nonprofit power supply agency. We are governed by and for local communities. Our 70 municipal members come from all corners of the state. And since the spring of 2023, so going on 22 months, we've been delivering low-cost competitive supply options to consumers, and in the process helping consumers to realize more than $20 million in bill savings. So the Community Power Coalition's interest in this bill is acute, and I believe may be addressed through the friendly amendment brought forward by the Department of Energy. And that is in regards to Section 11, which is repeal of RSA 362A9 Roman 8. We did have some concern with that, but understanding from the department that that is actually a typo and should reference Roman numeral 18, we are okay with that change. So no further comment.
Questions? All right, seeing none. Thank you for your testimony.
Thank you very much.
Alex Seidel and Ben Martin, I think it says. Good morning, gentlemen.
Good morning. Good morning, Senator Pearl and fellow senators of the committee. I'm Alexander Spidel, Senior Advisor at the New Hampshire Public Utilities Commission, and I'm with Ben Martin McDonough, who's also Senior Advisor at the Commission. The Commission would like to indicate to the committee that it is neutral regarding this bill. The Commission is amenable to some fine-tuning regarding the consumer complaint process, but we'll be monitoring that. And also, the commission is interested, very interested in understanding as the process develops regarding this bill as to whether there will be a shift in responsibility and oversight for rate making in the field of net metering tariffs and charges. That is something that the commission is very interested in, and we haven't seen a clear indication of whether that legislative intent is built into this bill. So that would be the statement of the commission at the present time.
Thank you. Questions from the committee? Excuse me, Senator Waters.
Thank you, and thank you. Could you point to the sections in the bill where that question is raised about who has responsibility?
Yes, I would look in the first instance at section 3, net energy metering.
Yep.
And there's a change in language where standard tariffs providing for net energy metering shall be made available to eligible customer generators by each electric distribution utility in conformance with net metering rules adopted by the department. That's the insertion on line 19, and orders issued by the commission. So the commission was curious as to what the ambit or the intent of that language was in terms of whether the pricing structure of net metering will now be under the control of the department or whether the commission would retain control over that element.
If I may follow up.
You may.
So, I mean, I understand the concern and the, how do we sort these things out? I mean, one way to read it would be that the policies adopted by the department are going to reflect the orders issued by the commission, but that's not clear here. So
Yes, sir.
Do you think that you could work with the DOE to have some language that might clarify just what that relationship is going to be?
Yes, Senator, I could take that back to the commission and inquire about the scope and the possibility of that being done.
Yeah, thank you.
Further questions? Seeing none, thank you for your testimony.
Thank you all. Thank you.
Sam Evans-Brown.
Thank you, Senator Pearl and members of the committee. Sam Evans-Brown, Executive Director of Clean Energy New Hampshire. We are in support of this bill and certainly the intent of cleaning up the net metering statute. I'd like to convey a fair portion of my life is devoted to explaining the net metering statute to folks who don't understand it because it is so out of date. So cleaning it up, I think, should be a priority. Just a bit of history here. The standard tariff language refers to the net metering, the initial net metering offering that was the one-to-one. Any kilowatt hour you generated was reimbursed at the same rate as the kilowatt hour you consumed. That is no longer open. That program is now closed. It closed in 2017 with the issuance of a PUC order that established net metering 2.0 and gave that net metering rate a haircut. So the standard tariffs are no longer open, and now we're governed by what is referred to in the statute as an alternative tariff. I would just flag a couple issues with this. The first is that there's a small amount of concern for me and my organization about the deletion of lines 19 through 21, where it says each net metering tariff shall be identical with respect to rates, rate structure, charges, and the tariff to which the customer generator would otherwise take default supply service from the distribution utility. There's no reason to think that the PUC would go back and retroactively alter the standard tariff for those folks that are grandfathered in, but the deletion of this sentence would certainly open up the possibility that the commission could do that. And given some of the commission actions we've seen lately, I think it's a good idea to be crystal clear what the legislative intent what the legislature's intent for the folks that made investments based on the program that was in existence prior to 2017, what your intent is for those ratepayers.
Sam, which page was that?
It's on the first page. So right at the beginning of the deletion of the section regarding the 100 megawatt cap. I think that there's no reason to get rid of that sentence. I think it can be easily put back in with minimal concern. The second issue that I would flag is in that same section, and it's the same language that Mr. Spidell just referenced. This is a reference, as far as I can tell, to the 900 rules. The 900 rules govern how net metering and group net metering are carried out by the department. Those rules were adopted by the Public Utilities Commission, but then when the Department of Energy was created, they were moved over to the department. And so I see this as a cleanup. They're just making sure that the statute is aligned following the creation of the Department of Energy. But it's important to note the 900 rules are being redeveloped as we speak. They're being rewritten and revisited. And those rules will apply to the alternative tariffs as well. If I were in charge of drafting this bill, I would argue there's a little bit more cleanup that could have been done to make that crystal clear that, any new market entrant could come in, could read the statute, they could understand that all net metering is now being done under the alternative tariff. The alternative tariff is governed by rules that are being administered by the department. And I'd be happy to provide some suggestions if folks are interested in those. But we've been operating under this paradigm for a couple of years now, and we've been surviving. So it's perhaps not absolutely imperative that we do those cleanups. So that's all I have to say.
Well, Sam, if you have suggested edits, the committee is always open to seeing them. Questions from the committee? All right, seeing none.
If I may just
Senator
ask.
Waters.
So, thanks, Sam. So, part of it seems to me be a question of timing, in that the clarifications here that we just previously heard and about what you're describing are what, the standard tariffs, the alternative tariffs, Rule 900, and how is it that things are parsed out in that sequence? And so might it make sense to put some dates in here to say that anything order issued previous to or subsequent to? Would that be a way of clarifying it?
It really, this, in my opinion, is a really great opportunity for all the parties involved to just sit down and talk this through. Because I wouldn't want to hazard a suggestion that wouldn't get the support of the PUC and the Department of Energy. This really is just about providing clarity about where we are and where we're going. And so that might be a solution if the relevant entities are interested in going down that road.
Thank you. Thank you, Mr. Mayor.
Further questions? All right, seeing none, thanks for your testimony. Anybody else that would like to testify on Senate Bill 108? All right, seeing none, we will close the hearing. Next up is Senate Bill 109, and we'll open the hearing. I see the prime sponsor, Senator Lang, is here. Welcome.
Welcome, Mr. Chair. Thank you, committee members. I'm Senator Tim Lang from Senate District 2, covering the Lakes region all the way north to Campton and Thornton. Before you, Senate Bill 109. Senate Bill 109 seeks to do a couple things, probably the most important of which is it establishes some timelines that the agency must act on. And if they don't, then it has provisions for that. And then the second thing it does, when we're dealing with alteration of terrain permits, Fish and Game reviews these alteration of terrain permits, and they can issue basically a fee requirement for for mitigation for a project to go forward. And what the second half of this bill does is establish to fund the Threatened and Endangered Species Compensatory Mitigation Fund, and allows those fees that are being collected on these alteration of terrain permits or permits to be able to go into this fund, and that fund will be used to help mitigate and offset in other areas where we may trade one piece of land for another, basically. But that's the short version of the bill. My understanding is we may see this bill, we may see this language or something similar to it in a low-numbered House bill that'll be coming shortly to the House, because this is part of the governor's efficiency language to move permitting and making sure that we're not denying or delaying permitting. That's the short version of the bill.
Thank you, Senator. Questions from the committee? Senator Rowe.
Thank you. As I read this bill, which is scary, it seems like we're asking Fish and Game to do more in a shorter period of time.
So thank you for the question. So we're not actually asking to do more. Back when my last term in the House, I was chair of Fish and Game, and we had a bill come in from Senator Bradley to deal with this lawsuit that was filed that required Fish and Game to take a look at this issue. However, we didn't have anything in law that actually allowed them to do it. And so we passed a bill when I was chair of Fish and Game 2 terms ago that gave Fish and Game the authority to do this work. So they're already doing it. But what we're doing now is setting timelines and requirements around it. So Fish and Game is already doing the work. They're already required to review and look at this. The other half is we're dealing with the funding piece, what happens to the money and where do we put it?
Can I follow up? Thank you. So we're giving them a shorter time frame to do the work. And the fiscal note says they need more positions. My question really is, since they're the only department that's self-funded that can't fund themselves, is it realistic to give them, you say not more work, but a shorter period of time, knowing they need more positions that they can't even pay for?
Thank you for the question. So again, this has an FN. It's going to go to finance and deal with the fiscal implications of the bill. But what I will say is this, is that if we have a housing crisis, and if we have a crisis in development in the state of New Hampshire to have housing for our citizen, we have a less than a 1% vacancy rate in rentals, we have a very low number of houses on the market, we need to speed up development. Right, it has to happen if we're going to close this gap. We can't continue to have agencies work. I was talking to a developer yesterday, and they said almost 40% of all their projects never get off the ground because they're waiting on permit and the financing just falls through, and they let it go. But it's because they're waiting on permitting. So we have to speed up permitting if we're going to allow this to happen. So this puts some timelines on the agency so they know it's not an open-ended thing. If you want to change the number, let's talk about what number you want to change it to, but it shouldn't be an open-ended number saying we're going to file a permit and whenever we get around to it, you'll get your permit. And this bill does the opposite of that. It sets timelines so people know when they file paperwork with the state when they can expect a response.
Follow?
Good. So if this bill goes to finance, are you planning to bring an appropriation for those positions?
We can talk about it in finance and how that works. In Ways and Means, we haven't looked at the revenues yet for Fish and Game. Fish and Game has a couple of places where they still need to work on revenues. One of them is we authorized in this legislature online OHRV registrations. They still haven't done it, as far as I know. And we did that like 4 years ago. And the agency still hasn't acted on that, which from talking to the people in that OHRV industry, a lot of them go to Maine and do it because they can do it online. And they'll just register their OHRV in Maine, yet we're losing that revenue and Fish and Game is losing that revenue. So there are places where Fish and Game can still act to increase their revenues, but I'm not even estimating their revenues yet. As the Ways and Means chair putting them ahead, we have not talked about that yet.
Oh, thank you.
Further questions from the committee?
Yeah, if I may.
Senator Waters.
Thank you, Senator, and I do agree that we do need to find ways to tighten up timelines and so on. And I do hope that in a bill we'll see this afternoon and in finance, there'll be some mention of the funding for these positions. But I guess my largest concern is that we are regulated by federal law on endangered and threatened species and their habitats. And that's why Fish and Game is such an important role to play here. And we've always been cautious because we talk about housing crisis, but you know, if you're endangered species, it's like forever. You lose your habitat. I particularly wondered if you could talk through part 3 on the first page and just how do you see these changes working out? In terms of the other departments and their actions and the provisions of paragraph 4 by the others departments. I mean, what is this trying to get at?
So again, my understanding is this was clarification language that was necessary for Fish and Game to be able to do the work that they do and engage other agencies in what needs to be done in order to pass. But you can probably ask the agency as well about that.
Okay, thank you.
That's it. Further questions? All right, seeing none, thank you, Senator. Thank you. Well, we've talked a lot about Fish and Game, so we might as well bring them up next. We have Dan Bergeron and Stephanie, I'm sorry, I can't read the last name. I'm sorry? Simmet, all right, come on up and introduce yourself.
If I may, Mr. Chairman, welcome our new Director of
Yes.
Fish and Game.
I was just going to.
Yeah, well, there you go. I beat you to it. We can both welcome.
So, welcome.
Thank you very
Happy
much.
to have you here.
I'm thrilled to be here actually in New Hampshire, so thank you. Good morning, Vice Chair and committee. It's a pleasure to be here this morning. I'm Stephanie Simic, the Executive Director for New Hampshire Fish and Game. I have with me Dan Bergeron, who is our Wildlife Division Chief, and we're here to testify on SB 109 FN. First, I'd like to just state that we recognize the challenges facing environmental review and permitting across the state, both from a natural resource perspective and a development and growth side. The need for environmental review has escalated. Environmental permitting has escalated and increased incredibly over the last 5 years. And during that time, the state has taken actions to develop what we felt was a responsive process for environmental review and permitting. Admittedly, we are not the only agency involved in that. So as one of multiple agencies involved in this process, Fish and Game strives to be efficient and effective in the process for all parties involved. I will say that in February of 2022, that's when the new Fish and Game rules were put into place to refine this program. It was intended to provide transparency. It was intended to facilitate a comprehensive approach. And admittedly, since that time, we've had a few growing pains, and we're aware of some of the challenges some of the applicants have faced during that time. So over this past year, New Hampshire Fish and Game has taken a significant approach to making improvements in our part of the process, one of which is restructuring our staffing to improve our data systems, to work more closely with the applicants, to include more recent and improving our outreach and information to the applicants so they understand what's expected of them. We've been working more recently with our partner agencies, and honestly, it takes a village to do all this, and it's important for all of us to work collaboratively. And we're committed to that. We're committed to our partners. We're committed to creating a comprehensive and effective environmental review program and process. And quite honestly, we're still in the infancy stages of this. So I'm asking for a little grace here. We are working on these things, but maybe not as quickly as some would like to see. We're supportive of the idea of creating an innovative and new ways to be more effective and efficient. We're on board with the governor's desire here. However, we do have concerns with this bill as it is written. We have outlined several of our concerns in the document that we just submitted to you. It's important to understand that this bill does not just affect alteration of terrain permits, but it affects our whole environmental permitting and review process within our agency. And Dan is here with me. He's going to highlight a few of our primary concerns, but I encourage you to read the letter that we submitted, and I'm happy to discuss any more details or questions that you might have. But it'll perhaps provide you a little bit more information so you're better informed on our current process and our concerns. Thank you.
Thank you.
Good morning, Vice Chair, members of the committee. As the director mentioned, Dan Bergeron, I'm the Chief of the Wildlife Division. So I'll try and briefly go through some of the concerns we have here. So for a little bit of background, so in 1979, the state legislature established the Endangered Species Conservation Act. That was under RSA 212A. And that granted New Hampshire Fish and Game the authority and the responsibility to protect threatened and endangered species. So key to that is the original section 9.3, which states that all other state departments and agencies, to the extent possible, consistent with their authorities and responsibilities, shall assist and cooperate with the executive director, and I'm paraphrasing here, for the conservation of endangered or threatened species. So essentially what this does is it gave the department authority to manage and protect these species, and it ensured that all other state agencies and the actions that they undertook, whether that was through funding or actions they authorized or carried out directly, complied with this statute and did not jeopardize the continued existence of threatened and endangered species. Currently, the way that works is Other agencies assist and cooperate with us, for example, through permitting and our consultation process. So we work with these other agencies, provide recommendations to try and avoid and minimize those impacts. So some of the proposed changes that this bill would do, we have concerns would remove some of the authority that the department has in our ability to protect T&E species. So specifically, I'll call your attention to lines 6 and 7 of the proposed text, where it adds language, as such other departments or agency determines is reasonable and prudent, to ensure that actions authorized, funded, or carried out by them do not appreciably jeopardize the continued existence of such species. So our concern is that what this does is it actually transfers authority that the department holds to other state agencies and allows them to make the determination on whether or not there's impacts to threatened and endangered species. Of similar concern, there's language in the new section 4F, which is on line 23, which states that no other agency shall include any recommendations from the executive director in a permit approval or authorization that exceeds its statutory authority. So Fish and Game currently is the sole agency that has statutory authority over threatened and endangered species. So our concern is that any recommendation that we would provide through a consultation process would be outside the statutory authority of another agency, and by default, they wouldn't be able to include those. The concern is that this could lead to scenarios where actions that are carried out or permitted by other state agencies are not in compliance, they jeopardize the existence of T&E species, they're in violation of the Act, and they could open the state up to litigation. The department, through its recommendation process and its recommendations on avoidance and minimization, it actually adds predictability to this process and protection for threatened and endangered species. So those are some of the concerns. We have concerns about the process and the timeline. So we actually, in our rules, have timelines that are spelled out. So those were established in our administrative rules, 1002 and through 1005. We also include review timeframes which are consistent with RSA 541A29, which already includes a 60-day review timeframe. The significant difference really between that and our process, though, is that when we ask, we have the ability to respond to an applicant, but if the application is not complete or if we need more information, the clock stops while we're waiting for the applicant to provide us with that additional information. It may be they didn't include everything that was required. It may be we need more information to actually determine what the impacts to threatened and endangered species are going to be. But the important factor there is that the clock stops and allows us to allows the applicant time to provide us with that information. From our experience over the past several years of administering this program, the time the department waits for a response is one of the most significant factors that kind of contributes to that overall time frame, not necessarily the time that the department is taking to review the applications. Also in section 4C, this requires the department reviews to be completed in a 60-day time frame. So if the information is not provided and the applicant does not voluntarily commit to an extension, the department would, in that point, we feel, be required to make a determination. And if we don't have the necessary information, then we'd have to terminate the consultation process and then have the applicant reapply and resubmit an application when they had all the information available. So our concern is that in the end, this might actually add time to the overall process for us to review an application, because we'll need all that information to determine what the impacts are going to be. Currently, we work with an applicant kind of throughout this process to collaboratively work together to find ways to avoid and minimize impacts. Some of the issues, if we have to terminate an application, so that's additional review time, as I'd mentioned. It would require additional application processing for our department, and currently we don't charge a fee for our review of any of these applications. And we have concerns that it might lead to somewhat of an antagonistic relationship between us and applicants when right now we work with them to try and come up with a solution to get to the end of this process and get a permit approved for them. I think an important thing to note is that since our rules went into effect in 2022, most of the reviews that we perform are done within that 60-day time frame. So from 2022 to 2024, about 82% of all the projects we reviewed were completed in that 60-day total time frame. Of the projects that weren't within that time frame, most of those were due to us waiting for an applicant to provide us with the required information. As the director noted, we're continuing to kind of work to smooth this process out and add some predictability for applicants. We're working on, BMPs or best management practices that add some predictability so that if applicants know that there's a certain species and there's some common things that we might ask for, then they can kind of include those up front, so that will add some clarity and some speed through the process. The last part of this is the mitigation. So point of clarification. So the Threatened and Endangered Species Compensatory Mitigation Fund already exists. That fund is already in existence, and we have taken money in to that account. The difference that the language in this bill does is it adds a requirement that we develop further rules pertaining to when mitigation payments are required and then how those are calculated. So in our administrative rules, 1006, we already have language that includes disbursement of the mitigation funds, but again, not a requirement for when those payments are made or the calculations. Right now, mitigation is one of several options that an applicant that we can consider with an applicant. However, it's not the only option, and it may not be the best option in all cases. And actually, oftentimes, there are other options that might be more preferred. We feel like development of these rules and determining how to calculate these, we would need, they'd be very species-specific, unique to the different situations, so it's kind of tough to get a one-size-fits-all. We feel like there'd have to be a lot of back and forth with different groups who this would impact. And likely take quite a bit of time. And in certain situations, there may not be a scenario where you can just pay mitigation, depending on what the impacts are to certain species. Those are kind of our main concerns, and we're happy to answer any questions you might have.
Senator Waters, question.
Thank you, and thank you, Dan. Thank you, Director. So I'd like to go back to the first page of the Act, Section 3. Where I think my greatest concerns lie. Would it be fair to say that the real reason that Fish and Game has the authority over a lot of this process in terms of endangered species is because you have the scientific expertise on your staff that another department just may not have?
Yes, sir, that's accurate.
So, if I may follow up, essentially allowing other departments to make determinations that kind of cut you out of the process might be made without the appropriate scientific basis. But isn't it the case that that might also put us in, that their actions might be in contravention of state and federal statute?
That's accurate as well. It puts us in jeopardy of litigation.
Yeah, if I just, well, I've got some on other parts of the bill, so if others, I'll come back. Why don't you come back to me, please?
Thank you. Thank you, Mr. Chairman.
Thank you, Mr. Chairman. Thank you, Director. Pleasure to have you here today. Help me out with this just a little. I'm appreciative of the fact that 80% of your applications are done in this time frame. I'm an applicant. I've submitted an application to you. How do I know when that clock starts? Are your applications processed online so that I can go in, I can see, opened up on this day, and we're off and running?
You want to answer that? I know.
Yeah, so currently the process is not done online. It's all through email communication at this point. However, we are required to respond within a given time. So we get the application. We were required to respond, I believe, within 30 days. And then we typically respond much faster than that. And, you know, if it's a complete application, that's great. Then we start working with the applicant to go through the process and work out different mitigation options or ways to avoid or minimize impacts. But the key is when we need to ask for more information, because sometimes we get applications that are nowhere near complete. And the issue for us is if that's counting against us, and there would be a concern that applicants could kind of slow roll the process and try and get a permit by default by just not providing the appropriate information.
If I could follow up, Mr. Chairman? Yes. So is the department in the process of being online with applications? Because I know your people are good people. I face value here that that's the way the process is going. I can understand that the department worried about people slow rolling. I've had experience with permitting in the past on something just as simple as a shoreland permit, that communication takes a long time to start. My question is your department in the process of becoming open enough so that we can see your applications and when they open?
So I'll answer that. The short answer is no, we are not in the process of preparing for an online system. The long answer is the reason I had turned it over to Dan initially is because the whole technology piece of Fish and Game is one of my major objectives since I've arrived in this house, because we are in the dark ages. I'm going to be upfront with you on our technology. However, technology costs money. And so I'm looking to see where we can be more efficient, and I'm looking forward to meeting you, sir, so that we can utilize some funding to perhaps bring us to some online systems. There was mention about the OHRV, and that is actually going online this year. This fall, we'll see it online. However, you know, given the status of our agency at this point in time, I don't have funding to support that. I don't even have all of our regions on the state system at this point. That's a technology need that I need for this agency for us to be efficient to then further serve our customer base. I love the idea, and I think we can get there. It's just going to take time.
If I could follow up one more. So we're in an antiquated system.
Yes.
And I understand funding being an issue. When that initial correspondence goes back with an email to the applicant, is it noting that the application was opened on and deemed complete in the very first? And do you have any idea, of the size of scope of the applications? Are the largest applications are the ones that are in that 20% that aren't being answered? Or where you're at with that?
You go ahead.
Yeah, so certainly that 18-20%, those would be the larger projects that have more potential to have a negative impact on threatened and endangered species. That said, the initial communication is still within the time frames, and we are still on a clock. So we are still required to complete this process within a 60-day time frame. Again, the key difference is that the current system allows for that clock to stop while we're waiting for really necessary information to make a determination. In the absence of that information, our staff can't determine what the impact is going to be, and we would have to stop the consultation process and likely have an applicant reapply when they could provide us with that information, because the alternative is a project goes through, it's not in compliance with the Endangered Species Act, and again, it opens us up to litigation, it opens other agencies up to litigation.
One more. Thank you. So the clock stops. You've sent a correspondence, an email, the clock is stopped. Do you tell them that you're 15 days into this process now and the clock is stopped and they need more response? So they don't start back on the 60-day clock when you ask for a response, do they?
The clock doesn't roll over. Are you, the clock does not roll over. It doesn't, I mean, in the sense, it doesn't restart as day one, once they respond. When they respond, it continues the time frame,
Thank you.
the initial 60 days.
Thank you, Mr. Chairman.
You're
Thank
welcome.
you.
I understand about the need for more funding for IT. I really do. And, but I did want to kind of talk a bit more about this statement, Dan, that you made about the no fee charge for the review. Now, we do charge an alteration of terrain fee, right? So the DES. So what's the relationship? I mean, and I know this complex relationship about the funding of these positions in relationship with DES. But would there be some interest in having a fee for the review that you undertake, or is that assumed to be subsumed in the DES?
I would say we would be open to the consideration and discussion of fees and where they should be placed. However, I want to be respectful of the governor's office and their desires for no fees.
Okay, all right, so if I may follow up. So the question is not on this particular one, but just a general principle, which I know we all share, that we don't
Right.
increase fees or create new ones. But in a case like this, I'm not sure how you function as a self-funded department without either some funding for the positions or a way to provide some revenue for the review process.
I would agree. And I'll just say that, you know, currently we're working with DES on a memorandum of understanding and agreement about this and other arrangements that we work closely with them on. And our conversations will likely turn into, you know, funding and sources related to fiscal health and wellness of our agencies as well, so.
Thank you.
Senator Whitmore?
Thank you. And two questions. How many threatened or endangered by state or federal designation species do we have?
The exact number, 200? Go ahead.
Yeah, so we actually have the supervisor of our non-game program here, Mike Marchand, would probably have the answer for that, so.
Okay, I'll hold that. If I could ask another question, would the department be open to an MOU with DES to share part of the fee so that it could cover the cost of your review?
Yes, we're open to any option that may help us be more efficient and effective and help us fiscally.
Thank you.
You're welcome.
Seeing none, thank you very much.
Thank you.
Adam, do you want to come up? Yeah.
Morning, Senator Avard and members of the committee. My name's Adam Crapo, for the record. I'm the Assistant Commissioner at the Department of Environmental Services. And I have Phil Trowbridge here, who's our manager of our Land Resources Management section of the DES. DES supports the intent of this legislation. I'll go through some of the background on why this is required and all of that. An application requirement for DES for wetlands and AOT permits, which we do around 2,000 wetlands permits and around 230, 250 AOT permits, depending on the state of the economy. And on all of those, an applicant is required to check through what is called the Natural Heritage Database data check tool to see if there is a hit for a threatened or endangered species or its habitat on the proposed development site. And whether or not it's there or in the vicinity of the proposed development. If the property is positive for a hit in the database that provides that information, they need to consult with Fish and Game on measures to avoid, minimize, and mitigate for impacts of those species and their habitat. These I want to be explicit here. You know, these consultations are absolutely critical to ensuring we preserve threatened and endangered species here in the state. DES has conducted an analysis for just our alteration of terrain. Again, that's around 230 permit applications per year on those that needed time extensions, and there are around 81 of those. And for context, we have 50 days to see if we need more information on a permit or to get the decision out the door. And then if we don't have all of the information to make a decision within those 50 days, we send a letter to the applicant asking for more information. And then once they provide that information, we get another 30 days to make a decision. So when I say time extensions, it's going beyond that 50 and 30 days, so the combined 80 days to make a decision. So there are around 80 of those instances out of the 230 that AOT permits that we had, and more than half of those were because there was, whether it was due to the applicant not providing the information Fish and Game needed to make a determination, or because the process, you know, I don't know if it's maybe a staff, you know, not enough staff or not enough resources because they don't collect a fee, but there certainly is, there is an issue, and we are working through it with them to get to a solution through whether it's an MOA or another means to make sure that these permits are done in a more timely fashion. Like I said, we've been working with them over the last few years to streamline these processes. As mentioned, there was a court case that sort of created this a more targeted approach to making sure that these species were protected, and that was in 2019, I believe. And so since then, Fish and Game has had to develop this program, and it has been, as the director stated, sort of fits and starts and growing pains. They have improved significantly. However, we do feel like we do need to support this, at least a version of this bill or the intent of this bill, because it will help us as part of our permitting process to get to the governor's 60-day timeframe. That's her goal, and as you heard in our inaugural speech, that's her goal for all permitting in the state where it's possible. And so, you know, some things about this bill that I'd say, you know, it does require Fish and Game to take action on proposed projects within 60 days. It does have a release valve allowing for applicants to allow for time extensions at the request of the director. That's very similar to the approach that we take. You know, we have those, as I mentioned, those defined timelines. And if we don't have enough information on an application, we're forced to deny unless the applicant gives us permission to extend those timeframes. So this would put those timelines in statute. Right now, they're a similar construct is in the Fish and Game rules, as you heard. We know Fish and Game has concerns with the drafting of this legislation, and we're very open to working with them. I've talked to the director about this on acceptable language that achieves the same goals set out in this bill, maybe different language, but achieving the same goals to get to a 60-day permitting timeframe. Additionally, I would recommend waiting on taking action on this bill until you need to do so, as there are quite a few other proposals out there, and as you heard, there may be additional proposals in a low-digit HB bill that is going to be released in the next few weeks. And so we want to make sure all of this is done in a coordinated fashion, and that you know, things aren't passed and accidentally, you know, conflict with each other. And so I would make that request. So I'll turn it over to Phil to see if there is anything I missed. I'm sure there is, but you know, I appreciate the committee's giving us an opportunity to comment on this legislation and you know, try and solve this very important issue for housing and other development in the state. So.
Good morning, Phil Trowbridge for the record, Manager of Land Resources at DES. I actually don't have anything to add. I think Adam covered all the points.
Okay. Questions from the committee?
Great.
Senator Waters.
Yeah, thank you, Mr. Chairman, and thank you both. So I think there are really two things in the bill, would it be fair to say, that there's the timeline issue, and I hear what you're saying about that. But I wondered about the concerns about essentially cutting Fish and Game out of determinations potentially on endangered and threatened species and habitats. And would that open DES or other departments to potential lawsuits? I mean, CLF, I don't think that attorneys are going to be an endangered species if this bill passes. Because they're going to bill a lot of billable hours out of that. And so I'm wondering whether that first part of it is really, the first part of the bill is really needed in terms of the timeline issues that you're raising.
Sure. So, right now what we do is, we acknowledge that Fish and Game are the experts on threatened and endangered species. And I think we would continue to acknowledge that. And I would be concerned with excluding recommendations made from the Fish and Game department in our applications. And if we did do that, we want to make sure our permits are defensible. We have various appeals and various recourses for folks who are aggrieved by our permitting process, and for folks who have issues with applications that are submitted to us. And so, we would want to make sure that anything that we issue does not conflict with what Fish and Game would be saying in the testimony on a witness stand, for example, because if we did, we would be subject to potentially losing litigation. And so we work very closely with Fish and Game to ensure that anything that's included in our permits is defensible from a legal standpoint on the threatened and endangered species issues.
I could follow up on that, Mr. Chairman. So, as you look at that section 3 on page 1, I hear what you're saying, and good. But essentially, it seems to me what you're saying is that, well, we'd want to rely on Fish and Game, which means, well, Fish and Game and their scientists would do the review. That's what you're saying, they should. But here the language would say that, well, as a matter of fact, an other department can decide just, no, we'll just go on our merry way and not have them do the review.
Senator Waters, if I could just maybe give you an example of where there might be a legitimate reason for this. We do a alteration of terrain permitting as well as wetland permitting.
Yep.
And the jurisdiction for wetland permitting is pretty limited. And you can have projects that need a wetlands permit where the development, let's say, is going to be a much larger thing. It would be a subdivision or something that does not need an alteration of terrain permit. And the Fish and Game recommendations for that development may be quite broad regarding the uplands and species that inhabit the uplands, but that's outside the jurisdiction of the wetlands permit. And we've been advised by our legal counsel that we cannot put requirements in a wetlands permit that are outside wetlands jurisdiction. So there's sometimes a need to draw a line in terms of what the recommendations are and to the authorities that the department has for certain permits.
Thank you. And I would just say that may be in some cases, but the language of the bill is pretty direct in that, I guess what I'm saying is that I think the process we have in making those determinations and the involvement of Fish and Game and using their expertise and the positions that do what they need to, staff that do what they need to do is what you're saying. Isn't it what you're saying is that, yeah, that works, we work it out, but this bill would preempt that. Isn't that the case?
As Phil mentioned, in certain circumstances, there may be recommendations provided by Fish and Game, and I believe we have seen this very rarely, but in the past there have been occasions where there have been recommendations made that fall outside the jurisdiction of a permit, for example. So, in wetlands permitting, we're looking at solely whether or not the development can avoid, minimize, or mitigate for the wetlands on their property. And we make our permitting decisions based on our rule set and what's defined in statute. Sometimes, again, very rarely, recommendations would be made that would request that the applicant do something in the upland, which is not regulated by our wetlands permit. And so I think the intent of that part of the bill is to draw sort of a defining line between what we can and let me back up. The consultation is rolled into our permit. They are not two separate permits. It is rolled in our permit when we issue it to the applicant. And so I think the intent of that section of the bill is to allow, in the very rare cases where a recommendation is made that is outside the permitting scope of the agency issuing the permit, that we would not be required to include that piece of it, if that makes sense.
So if I'm, just my last one, I'm sorry to take the time. It seems to me that could you work with Fish and Game on some clarification of the language? Because I mean, I've been around, I know what you're talking about on the wetlands things in the uplands. We've been through that with a lot of bills in the past. But it seems to me that there could be some clarification here, because do you hear what I'm saying? It seems to me to be, that it gets us into trouble. And would you also talk with them about what might be possible about a fee structure that would address I mean, there's gonna be a bill later on suggesting that we have some funding for those positions, but it doesn't seem unreasonable on the existing fee structure to have a carve out or a particular fee addressing Fish and Game's work. So maybe those are some things you could talk with Fish and Game about and see if you can come back to us with anything.
Absolutely, and we are in the process of working with Fish and Game, and as I mentioned, we're very open to working with them on the language of this bill to get it right. On the fee structure, I think we would be reluctant to do sort of an MOA to unless we got an increase in the AOT or wetlands fees. Our fees allow us to staff up to meet our time frames, and we are bumping up against being able to make our statutory timelines. And I think the concern is if we were to do a sort of a fund sharing agreement, that unless there was an increase in the fees somehow, that we would be at risk of not meeting our statutory obligations. And so we will certainly work with Fish and Game on the language, but I just wanted to get that out there to make.
Understood.
Yeah.
But yeah, thank you.
Senator Rosenwald.
Thank you. So in Roman 3, as I'm reading this on page 1, it would require you to consult with Fish and Game to make sure you're not further endangering endangered or threatened species, appreciably harm them, jeopardize them. However, further down, starting on line 13, the rules that are required to be written don't include the habitat. So it seems like you'd have to consult with Fish and Game about the species, but you could do whatever you wanted about the habitat for those species. Are you concerned about that as I am?
So, Senator Rosenwald, that text I think that you're referencing from 13 to 16 is existing language in the statute, and we do consult with them on habitat and the actual species themselves. And so, we take a very conservative approach to this, that we from a risk mitigation standpoint, we want to make sure that for anything that's incorporated into our permits, it is protecting the threatened and endangered species and their habitat. And so the department takes a conservative approach to that. I think Fish and Game specifically would be able to answer the question about what's included in their rules and what's not. But that, from the departmental standpoint, from DES's standpoint, we do work with them very closely to ensure both those things are protected. And Phil might want to add it.
If I could add something to that answer, that section there is meant to apply to certain state, departments within the state who have wildlife programs and are addressing them directly. So it's meant to say we shouldn't have duplicate state rules when they're required to follow federal rules. Thinking of particular highways projects and things like that.
Thank you. No, I understand that, but what's new is that you can take action that you think is prudent or reasonable, but the rule has to do not with the habitat, but with the species themselves. So it seems like it's giving DES the ability in this, because of lines 6 and 7, the ability to not think about Fish and Game's warnings on habitat.
And how this practically works, Senator, is that the applicant themselves work with Fish and Game to begin with in the first instance, right? So the applicant will go and consult with Fish and Game. Sometimes it's concurrent with our process, sometimes it's before our process, and sometimes it's very late in our process. It really depends on how familiar the consultants that they hire are with our rules and with the Fish and Game requirements. And so oftentimes what happens is, I would say in the majority of cases, it's actually the applicant that consults with Fish and Game directly, and then we get a letter from Fish and Game as well as the applicant that shows the recommendations that are provided. I think our support of this legislation is really around the timeframes and trying to get down to the 60 days, and it's really limited to that. And working with them on the third, I believe it's the third page, coming up with mitigation rules for threatened and endangered species, similar to how we do that with our wetlands mitigation in the state. And we would work with them on a stakeholder process and help them along the way as needed if they request it. So I think that's really the reason why we're supporting this. The first paragraph, we're certainly very open to working with them and working through any technical defects that the committee, Fish and Game, or stakeholders deem are there. And so I think that's really the intent of our support. So.
Yeah, thank you. Do you think you folks can work out something with them and send me some language? Send us some language.
Absolutely, yeah, appreciate that.
As sooner the better, because we're gonna get backlogged pretty soon, because we're not gonna exec this today for certain. So.
Okay.
But any further questions?
Okay.
All right.
Thank you.
Thank you, Eric. Yeah. Is it warm in here or is it me? You have the floor.
Yep. Good morning, Mr. Chairman, members of the committee. My name is Eric Orff. I'm here this morning representing the New Hampshire Audubon. I serve on the New Hampshire Audubon's Policy Committee, as I have for several years. The New Hampshire Audubon position is we seek to have this bill sent in expedient to legislate. In full disclosure, Mr. Chairman, I should mention that I am a former Fish and Game employee. Looking back here at the much younger and no doubt smarter folks in the back of the room here, but in the 70s I became the Fish and Game Department's first bear biologist. So as a young 20-something-year-old bear biologist, you learn quickly. I do recall that when you walk up to a sleeping bear that you tranquilize, it's best to use a stick to poke it and never, never, never use your foot. So you learn things the hard way. And in this bill, I see that sleeping bear that could bite. And it's been discussed that the system now works pretty good. I mean, we went from 1,000 bears when I was the first bear biologist to over 6,000. We have 100 pairs of nesting eagles now in New Hampshire. 28 falcons, 28 pairs of falcons out at the Elza Shoals, and I helped a little bit. There's 3,000 pairs of terns when there was 12 when I first helped Audubon work on this. So The current system is working very well. And we've heard from several people that, we already do that. When we listen to them, we cooperate. Why poke a sleeping bear this morning? I would ask on behalf of the New Hampshire Audubon to send this bill in expedient to legislate. Thank you, Mr. Chairman.
Appreciate your testimony. Questions? Seeing none, thank you very much.
Thank you.
And our final guest, Meredith.
Thank you. Good morning. Meredith Hatfield for the Nature Conservancy. We have many of the same concerns as were expressed by Fish and Game, as well as with Audubon, so I won't go through each of them. We really appreciate the housing crisis that we have in the state right now and the need to ensure that we can try to meet the need for housing. But we would agree that the system has been working, and Fish and Game has been earnestly working to try to continue to improve it. We would love to be included in any discussions to improve the bill, because we certainly do think it needs improvement. And one specific suggestion that we have is, if you do proceed with any rulemaking requirement, it seems like Fish and Game would need more time than the end of this year. If this bill doesn't pass until the spring, and given their limited resources, it might be helpful to extend any rulemaking requirement into 2026.
Okay.
Thank you.
Questions from the committee? Seeing none, thank you very much. I have nobody else wanting to speak. Going once, going twice. We'll close the hearing on this, and we'll open up the hearing in 1 second here on this next one. So is the prime sponsor for SB 110 available? Shall we close the hearing on 110? I'm kidding. Yes. Oh. Yeah. Is Senator Lang out there?
I didn't see him.
Okay.
Okay, well, I'm Senator Cindy Rosenwald from District 13, and I'm introducing Senate Bill 110.
Questions from the committee? Seeing none. Thank you, Senator. Mark Brown? Welcome.
Good to see you. Thank you, Mr. Chairman, members of the committee. For the record, Mark Brown, Advantage of Government Affairs. I have with me today John Warzoka with Horizons Engineering. We're here today representing the Owl's Nest Resort, which is one of the largest real estate development projects in the Northeast. It's located in Thornton and Campton, and when it's completed, it'll have hundreds of residential housing units, hotels, event space, restaurants, convenience stores, EV charging, lakes, so a whole host of things. Brought John with me today because he can speak to, some of the technical aspects of, why we're supporting this bill and kind of his experience with AOT over the years. So with that, I'll turn it over to John. Thank you.
Sure. Thank you, members of the committee. My name is John Warzoka. I am the CEO of Horizons Engineering. We are based out of Littleton, New Hampshire, and one of our main lines of business is doing civil design, civil engineering design, and permitting in the state for various development projects, among other things. So I am very familiar with the side of things where we're in the trenches doing these alteration of terrain permit applications. It's interesting to sit here and listen to the other hearings this morning about, the discussions from the regulatory standpoint, as I sit there from the private sector standpoint of my teams are the ones that are doing these applications. An alteration of terrain permit, even a very basic alteration of terrain permit, is on the order of 100 engineering hours to complete that application package. And that's a very simple application. That does not include the site design. You can be hundreds of hours for a more complicated alteration of terrain permit application. And then the back and forth, certainly DES does a fantastic job to try to, turn permits around. They have staffing issues just like we do in the private sector, probably even more so. And for us, on our side and my client's side, predictability is everything, right? So being able to make it as hard as you want, but make it predictable. And one of the things is that with the short staff and the way that reviews are being done, oftentimes there's ambiguity in the process, which makes it more challenging. So increasing the threshold and doing anything to limit the number of these permits, let's focus on the more complex permits and lets us put time into the more complicated projects, both on the review standpoint and the design standpoint. The other observation I'll make is that one area, particularly like a client like Owl's Nest, that we bump into a fair bit is aggregation of disturbance. So basically, there's a 10 years, I understand it, there's a 10-year look back for land disturbance when you do an alteration of terrain permit review. So basically, if you've had an alteration of terrain permit on your project within the last 10 years, no matter how small the project moving forward, generally, you are required to do a new AOT. So we had an instance, I can cite an example a few years ago where we were working for a private school. They wanted to do 1,000 feet of sidewalk. They had done a skating rink a couple of years before that required an AOT, so we had to do a new AOT, 100 hours worth of work, plus the design for 1,000 feet of sidewalk. So certainly, again, there's certainly a need for these permits. We're not questioning that, but it's really just about the focus and what the threshold could be, because they are not simple processes to go through. You heard a lot about Fish and Game review, so there's multiple agencies that are involved with this. So that really is kind of from my perspective and my team's perspective that, again, we don't mind going through it. It's our job to do that. However, a lot of times it feels like these projects are, simpler than they are made to be by the process the way it is right now.
If we expand this, does EPA get involved at all?
So EPA is a bit of a separate, and I would let the DES folks speak to the regulatory requirements here on a federal level, but we are required to do stormwater pollution prevention plans for any disturbance over 1 acre. That's a construction-related permit that are much, much, much simpler than an alteration of terrain permit. There's no regulatory review. That is really on the onus of my professionals on my team to certify that those documents are in compliance with the regulations. And to this, we can't design something and put it out there for construction that doesn't meet current engineering practices. I'm going to get sued, my company's going to get sued, my people are going to be in trouble if we're designing developments, parking lots, et cetera, that don't adequately detain and treat stormwater, so you're not impacting abutters or anyone else. So there is a bar there already, aside from the regulatory requirements that we have to jump during the process. So it's not like there's no guardrails on us. Also, there's obviously local approvals as well. Those processes are widely variable depending on where you're working. We work a lot in the North Country. There's a little bit simpler review in many areas that we work, but not always. There's some very proactive communities that have very stringent requirements. So there's other requirements in the process that we have to follow. And again, my point is just anything we can do to make the process predictable helps my clients budgeting and time-wise in order to proceed with their projects. So, thank you.
Senator Waters with a question?
I do, but him first.
Thank you, Mr. Chair. You brought up an interesting point about the 10-year threshold and having to look back to 10 years and being caught in a small project and then having to start over again. Would you have any suggested language or anything to that effect on how to allow that look back, but also apply a threshold to it?
Yeah, I mean, I think that would be, and I would be really interested to hear what the DES folks have to say on that, but putting some guardrails and some very well-defined, limits on what triggers a new project. Right now, generally the way that we do it is if we have a small project like Owl's Nest, for example. Now they've done a lot within the last 10 years. Within the last 5 years, we've done probably 50 plus acres of disturbance. So, however, when we have a small little project to do right now, so such as we're adding 15 parking spaces somewhere in the resort. Right now, the way we typically have to do it is we will informally submit to DES, one of the reviewers, say, hey, we're doing this, what do you think? And there's a bit of subjectivity there. So that individual reviewer might be, well, yeah, you're okay, you can just do it. Or, well, we've got to do it as a formal amendment. Or, no, we want a full new AOT. So defining that a little bit better, and again, that's where I certainly like the proposed threshold in the bill to say the look back covers that, because that's pretty substantial. But I think there is some opportunity, to have further discussion on how to put some guardrails around that.
Thank you. Thank you, sir. Thank you, Mr. Chairman.
You're welcome. Senator Waters.
Thank you. So I understand from your testimony that basically what you want to do is just to say that you're moving up to 200,000 square feet for this requirement, but the bill language doesn't remove the requirement for the permit. It just says that there's no fee. I mean, you're removing the fee, not the requirement for the permit. So you'd have to still do the permit, but there'd be no fee paid to DES. That's what the language of the bill you've submitted does.
That's the way I read it.
But the point is, you want it to go to 200,000 feet.
Yeah, I think my point, and again, is that anything kind of consistent with the previous hearing, anything that can be done to help to better define and simplify the process for my clients as applicants is what we're trying to shoot for. So if there's ambiguity, I didn't read the bill that way either, but
that's for the under 100,000.
yeah. So, but again, that was the intent, was to try to at least raise the bar, raise the threshold to kind of streamline the process.
Well, if I may follow up, we could have very clear and predictable process for you, but still keep the same standards, right?
That is possible, yes.
Yeah, thank you.
Senator Rosenwald.
Thank you. I totally understand your desire for predictability. My question is, in reading the fiscal note, it says at the local level, municipalities may face increased costs to contract engineering firms for project reviews previously handled by AOT permits. And I wonder if that decreases predictability, because maybe Nashua would, but Hudson wouldn't.
So the predictability side is always in question on the local level, because every community is different. There's a different approach. I would respectfully disagree on average with that number that's put forth with the review. Many communities don't, on simple projects that may be, an athletic field for a prep school that's more than 2.5 acres of disturbance right now. That may not even require a peer review. The planning board might be comfortable solely taking care of that. Many of my clients are ski resorts, so ski trails. Right now, in most cases, there is no peer review on a local level for those projects, because you're taking woods and you're turning it to grass. There's really not a lot of impact from a local perspective on that. So it is highly variable, but I would say that in my experience, personal experience with my teams, that budget range that's put forth is probably on the high side for what it would take. And oftentimes, communities won't necessarily default to DES for review. If they have their own criteria, I can think of one community that's got their own stormwater criteria in place that are more stringent than what DES requires. So they don't even really consider the alteration of terrain process. They're doing their own stormwater review. So I think it's tough to make a blanket statement on that. It really depends on where you're working.
Seeing no further questions, thank you for your testimony.
Thank you.
All right. James Sununu.
Thank you, Mr. Chairman and committee members. My name is James Sununu. I'm here representing Waterville Valley Resort. Waterville Valley Resort is a four-season resort in the White Mountains not surprisingly, Waterville Valley, New Hampshire. We are one of the largest employers of full and part-time employees in the North Country. Thank you for the opportunity here to speak today. I'm here in support of SB 110, which I would also speak in support of, actually, to the point Senator Waters just made, where it raises the fee for the fee threshold for alternative trade permitting, but also suggests that the threshold itself should be raised from 100,000 to 200,000 square feet. And I'll speak to some of my experience as to why I believe that would be a benefit. Although we've been proprietors of the resort for almost 15 years and have worked with the Forest Service, DES, and other agencies on permitting and on-mountain projects of various sizes, it's only recently that we have learned firsthand of the impact of the alteration of terrain rules, especially as it relates to housing. In our case, we proposed and eventually built 21 units of housing on what ultimately totaled about 3.5 acres in the town of Waterville Valley. Initially, this project did not exceed the AOT threshold, but was still subject to all the customary local and state regulations regarding stormwater, wetlands, wildlife, etc. However, when the success of the first part of the project led us to add a second phase, we did cross that 100,000 square foot AOT threshold, and the result was many months of back and forth at DES, costing tens of thousands of dollars in engineering fees, and ultimately hundreds of thousands of dollars of additional site costs to comply with the ever more strict stormwater rules that come into play due to AOT. The irony of this is that our engineers and our site contractors in the end felt that the more stringent rules did not actually improve any of the stormwater management that went on site. Fortunately, in the case of these housing units, given the economics of the market in Waterville Valley, we were able to absorb these additional costs and complete the project. However, I have great concerns about the continued impact of the enhanced AOT rules on costs for other relatively small projects if we try to move them forward. In particular, developing multifamily housing in Waterville Valley, where none currently exists, is only marginally economically viable in the current construction environment. If such a project exceeds 100,000 square feet, which is only 2 acres, then tens of thousands of dollars per unit of additional cost will make the project impossible. Increasing the threshold to 200,000 square feet, just 4 acres, will provide much greater probability of access to smaller, desperately needed housing projects, while still subjecting those projects to an entirely appropriate scope of state and local rules on stormwater, wastewater, wetlands, and wildlife protection. Reserving enhanced AOT permitting for larger projects where the additional costs are more easily absorbed is a very reasonable compromise on how these rules are applied. There has been much talk over the last few years about the housing crisis here in New Hampshire, in particular the missing middle of reasonably market-priced housing that does not rely either on difficult-to-secure subsidies or the economics of high-rent, high-priced markets like Seacoast, New Hampshire. Based on our experience and many conversations with experienced developers, engineers, and others in this industry, I strongly believe that the cumulative effects of new rule after new rule from multiple state agencies is a significant contributor to the breakdown of economics of this type of housing. And SB 110 can be a small but significant step to alleviating some of those pressures while still providing more than adequate environmental protection. Thank you.
Thank you for your testimony. Questions from the committee?
Yeah, if I just.
Yeah.
Thanks for being here and given your expertise. You know, we had earlier the fact of the EPA, anything over 43,000 square feet, they're going to require to the storm water. So how does, I mean, you'd have to continue with that requirement anyway. So how does that relate to your issues about stormwater compliance and costs in this process?
Well, as you said, you still have to comply with those EPA rules about stormwater for over 42,000 square feet. So any project over that size has to still meet those rules. In our case, going from under 100,000 to over 200,000 added an entirely more complex stormwater retention and treatment regime that is imposed by DES, not EPA, and which our engineers felt did not really do anything to to improve the stormwater mitigation on site, but cost several $100,000s more because the structures that are needed, the materials that are needed are much more expensive, much more site work involved, much more complicated in-ground retention basins that have to be built, as opposed to the standard stormwater retention basins that were part of the first phase of the project, which they believe were entirely adequate for the entire project. But AOT imposed this much higher level of requirement on these stormwater basins, which costs significantly more. My concern is if I try to build a multifamily housing project and have to build these much more expensive structures, that the economics of the project break down and it cannot be built. It's already very marginal and would have to charge very high rents for a North Country market to be viable, but we still are interested in doing it. There's no literally no multifamily housing in Waterville Valley, and we would like to build that, but it's very, very difficult to make the projects work financially.
So the EPA doesn't get their nose bent out of shape if we increase it to...
I can't speak for the EPA, but if the EPA is already at 42,000 and we're at 100,000, I would have to believe that there's obviously already some, coordination going on in there with those rules, and that going to 200,000. I mean, I'm not aware of anything that would do that. I mean, again, if there's federal rules in place that have to be met for stormwater, then we're already meeting them. And so if those rules are more stringent than what's required at the state level, then we're already having to meet those. And I think the engineer who's just spoke here, and I have a letter from our engineering firm speaking to some of the same issues, is, localities are already having to meet very significant standards for stormwater, wildlife protection. We all have an interest in protecting the environment. There's no question about that. But there also has to be some give and take on how stringent those things come into place, or we're not going to be able to build anything.
Yeah, and thank you. It's very helpful. I mean, I think we all understand the feds really don't have a sense of particular projects in our landscape and so on, and that we also kind of understand that at the local level, it can be hard for them to have the expertise in the engineering and the staff and so on to figure out just what kind of runoff and the effects of it might make. But I guess what I'm trying to get to is that, hearing what you're saying, do you think that there'd be a possibility of crafting legislation that would not simply eliminate the 200,000, but say that would be a default unless the state made a compelling argument that, in fact, the stormwater control and so on ought to be considered for that period, that area, that land between 100,000 and 200,000? I mean, that would not just throw it all out, but to say that it would put the presumption of some kind of demonstration of the need for that onto DES rather than onto you at the get-go.
I think, yes, I think there's certainly more than one way to skin the cat in terms of relaxing a little bit the regime that's in place and granting more flexibility, especially to smaller projects where additional costs can be make or break. I mean, you have a much larger project over 10 or 20 or 50 acres. The size of that project, you can more easily absorb the additional engineering and site costs of something more stringent. So, but to your point about the localities, I'm not sure if it was mentioned before, but right now localities can and do bring in third parties to do engineering review, and they require the applicant to pay those fees. So it's not a burden on the locality because the applicant can pay the fee. And, we are certainly prepared to do that in cases like this. But I think in addition to AOT, though, as an adjunct to this, I would encourage the legislature to take a very close look at the rulemaking regime that goes on in the state. I'll use DES as an example, right? At any given time, you have a dozen pending rules. Right now, there's 16 or 17 pending rules. All of those have rulemaking notices. If you look at those rulemaking notices, virtually every one of them has a cost analysis as to what this would cost municipalities or businesses or residents of the state. Those cost analyses are made by the legislative budget assistant. And I'm sure the legislative budget assistant is very good at their job, but I don't think you can expect the LBA to have the engineering or construction expertise to analyze what a 50-page rule that imposes new engineered restrictions or requirements on stormwater mitigation or wastewater treatment could possibly cost. So those cost estimates come forward, and they're not based on any actual cost-benefit analysis that's done, but it's rule after rule after rule. There's 16 pending now. They just keep coming. And on the margin, each one might look small, But each one adds additional cost, additional cost, additional cost, and then the economics of these projects just break down. I think there should be a serious look at whether there needs to be cost-benefit analysis done before these rules are accepted. Right now, those 17 rules that I saw this week add up to 480 pages. And all those are probably going to come forward to JALCAR for approval. And 480 pages of technical rulemaking. Now, I know there's a lot of different things that drive those rules, federal regulations and things like that. But I think serious scrutiny needs to be paid to all of these before they are approved and go forward, because they just keep coming and they keep adding more and more and more, and make housing projects in particular. That's what I'm looking at, housing. Even though we're running a resort, we're now having to get into the housing business because there's not enough housing being built in the North Country by housing companies. And so, it makes those projects more and more difficult to be feasible.
Thank you.
Further questions from the committee? Thank you very much for your testimony. Appreciate it. Alex? I think it's Alex. It's Alex, right? Yeah.
Good morning, Senators. I sent in written testimony on both bills, 109 and 110 last night, but I just wanted to follow up in person. I want to make sure that the process is really clear here, that when we design a residential subdivision, and I've gotten 700 units approved in this state in the last 5 years, we pay our civil engineers to design according to the rules, and then we pay the town's third-party engineer to review and make sure that our engineer did their job that we paid for. They both have stamps certifying that they know the rules and the regulations. And then these projects get sent over to DES for review, oftentimes with more stringent requirements. I said in my testimony to you that 100,000 is not what it used to be. Because of the shift to open drainage and the way that we design projects, I have a residential subdivision in Stratton, New Hampshire that is just 6 lots that was 97,000 square feet of disturbance because it's on a new road. And so that required, in order to avoid an AOT permit, that we go completely build our road and stabilize that road before we could build on any of our lots. So we're not talking about massive projects that are qualifying for these DES permits. In some cases, certainly there are larger projects, but in some scenarios, these are 6 or 10 or 13 lot projects. So raising that threshold will just expedite the housing for those smaller projects that don't really need this third-party review. We have another project that we're working on, 13 lots on a new road in a seacoast town, and we're at 120,000 square feet of disturbance, so we will have to go through the AOT permitting process. I'll receive my local approvals in March for that, and we expect that those lots will not come online until next spring because of the process that it takes with DES and Fish and Game. And I'd just like to say, as part of all of these conversations that we've had, that the timeline that it takes to get these permits with the elusive stopping clock has such far outweighed costs to any increase in permitting fees that may result. So if there is a crisis for DES and Fish and Game that would be solved by a slight increase in fees, the cost for us to carry these projects and lose our road contractors and miss our markets are far more exponential than any increase that you would see in those fees. So the impacts of these things when we have these DES permits and it requires us to wait a year to get housing in the ground is far beyond 1 year of missed opportunity. It's 10% carry costs on our construction loans. It's our road contractors saying that because our permit didn't come in 60 days like we thought it would, they've now moved on to another project and we have to hire a more expensive road contractor. And it contributes to the bottom line. And unfortunately, we have to pass these costs along to the folks who are buying these homes, making them unaffordable. So anything that we can do in increasing that threshold will get those smaller projects off the ground more quickly and allow the third engineering review to be where it needs to be on the larger, more impactful projects.
Questions from the committee?
Nope, thank you.
Thank you.
Thank you. Meredith?
Thank you. Meredith Hatfield for the Nature Conservancy. We had concerns when we read the bill about what it was trying to do, so this conversation has actually been very helpful. And it sounds like we've also heard in the industry some support for having users pay for the costs of what it takes the state agencies to do. So it seems like that is something to explore. But generally, we are concerned about raising the threshold. As I said before, we understand we're in a housing crisis. We need more housing. But we also need to be careful about water resources and the environment that we all depend on for so many things. So we would want to proceed carefully. And if predictability and clarity is really the problem, then let's focus on solving those problems. Thank you.
Thank you. Is there anything in the bill that would affect the water quality that you're concerned with?
Well, that is a question really for us. When you increase, I mean, I know the way this is written, it looks like it's just the fee, but clearly the intent is to increase the threshold to seek a permit. So when you increase that threshold, it's an open question of what are the environmental impacts. And it's not just impacts to species and habitat, it's also potentially an impact to people, because people are going to live in the houses. What are the environmental and public health impacts? And those are very hard to quantify, but I think that the system we have in place today is our best approach currently to try to ensure that as we build more housing, people have access to things like clean water.
Questions from the committee?
Yes,
Senator Waters.
So thanks, and I hope that we'll find some way to find a middle ground on this, because runoff is a serious issue, and isn't it the case that what we've seen over the last couple of decades in New Hampshire on some unfortunate examples of consequences of runoff, and somebody's wells or a town water supply or whatever, so that's why we've been cautious, isn't it?
Absolutely, Senator. And there are a number of bills that are trying to address the housing crisis, in various ways, including maybe reducing minimum lot sizes and things like that, which we think really merits exploration. But again, if people don't have access to water and sewer, we do need to make sure that every lot that we live on can support water and sewer, a well and a septic system, taking into consideration things like stormwater runoff. So, it's a complicated area, and, it's great that so many stakeholders are engaged at this point.
If I may follow up, because it's not just whether the water runoff might eventually turn into groundwater pollution, but it's also the nitrogen runoff and other factors.
Absolutely.
Too. I know that's big time in my area around the Great Bay.
Yes, absolutely.
Thank you.
Thank you.
No further questions. Thank you very much. Phil?
Okay. Thank you, Mr. Chairman and members of the committee. For the record, my name is Philip Trowbridge. I'm the manager of land resources at DES, and with me today is Amy Clark.
And I'm the Bureau Administrator for the Alteration of Terrain Program.
So I think what I'd like to do is just start quickly on some of the questions that we were talking about of why do we even have these permits? What is the thing that we're trying to prevent? Stormwater pollution is the #1 source of water pollution in the state of New Hampshire. When left untreated, it's going to be affecting our drinking water supplies, our rivers, our estuaries, our lakes. And as you well know, we're dealing with a lot of cyanobacteria issues, which are very expensive for remediation. The other main issue is flooding. We've seen a lot of flooding in the state, and so stormwater regulation is about trying to prevent flooding and erosion that affects our bridges, our roadways, our culverts, and our neighbors. The AOT permit is meant to do the reviews to make sure that the projects are not going to be having these impacts on the abutters or these assets of the state. The threshold that we've had in place now, this 100,000 square foot threshold, has been in place for 3.5 decades. It's 2.5 times the applicable federal threshold for the construction general permit. So it's already pretty high, and it deals with large projects. For your average subdivision that's doing single lot development, that equates to a 25 lot subdivision. Fairly big project to do construction. And we already do have a provision in our rules that is a little bit of a break for housing of subdivisions when they're doing on-lot construction or single lot construction. Once they built the road and subdivided, that the on-lot impact is not considered. So in effect, it doubles the size. So it really is already a 200,000 square foot threshold for that type of development. And notwithstanding what my Alex mentioned regarding some smaller subdivisions do require AOT because if they're grading the whole lot or something like that, they have to actually impact all of the terrain to make it work. So it's fairly large already. Now, moving the threshold up, one of our concerns about this is that you can still have big problems with projects that are under 200,000 square feet. 200,000 square feet is roughly 5 acres, which in the construction industry is recognized as the threshold by which you don't want to open a site any more than 5 acres at a time because to manage the stormwater on that site is very difficult. You need, pretty extensive stormwater controls and sometimes special technology. So a site of that size that has no controls can ultimately cause problems. It's not theoretical for us because we've seen these problems. We've seen abutter impacts where land is cleared, which mobilizes contaminated soils, bringing heavy metals down onto a property in Sugar Hill. We've seen it where people call us with their basement flooded because of the development that happened next door, or the poor well water quality. We also see the impacts on the infrastructure, town culverts being overloaded with sediment, or slopes being blown out and affecting DOT roadways. And then finally, we've seen the impacts to the resource themselves, the impacts of sediment deposits in brooks and rivers affecting fisheries. And we also have seen things that I would consider more aesthetic in nature, where we've seen development on lakefront properties on steep slopes that have caused eyesores that are visible for miles. We address these issues through compliance, which we do. We follow up on them, but it is way, way, way more expensive than permitting. It takes many years to restore a site if you can restore it at all. And one thing I'll just mention regarding what we call the larger scheme of development, which is the 10-year look back that came up in the previous testimony. There's a good reason for that because the concern is piecemealing projects and doing a series of projects that come in at 90,000 square feet that add up to a very large project, but if they're always just below the threshold. We're certainly open to ways that we can put guardrails on that to avoid the circumstance where a short area of sidewalk is not needed. Not needed to be pulled in. We can do that, and I should say that we have exercised our discretion on projects like that in the past, and so we're certainly open to that. The other thing I'd mention is just unintended consequences, and there's been some discussion about the reviews at the municipal level. In our experience, a lot of the towns in our state are not, rely on the AOT permitting for their site plans, that they don't have the expertise in-house, and it has been helpful to them, and that we do think there would be some confusion and lack of predictability if each town was going on its own. You asked about Senator Avard, you asked about the EPA. So there's really two issues. The construction general permit is what the previous people have mentioned, and that's a basic stormwater control permit. But there's also a thing called the water quality certificate for individual projects that, for larger projects that need an Army Corps permit. We certify our general permits by saying...
Is that based on the square footage?
Yeah, it's based on square foot. It's over an acre, depending on the type of project, or over 3 acres. 1 to 3 acres, the Army Corps can use discretion. So when they are saying a project is going to meet water quality standards, they first look at what other permitting programs exist, and are those going to be doing things that are going to help improve the water quality or protect the water quality. So the AOT program has been very helpful in that regard and for us being able to certify these projects. So it is a concern, and we can't speak for the feds, but we can say that there would be probably more concerns and potentially more desire to do individual water quality certifications on these types of projects. The other thing I'll just mention is, in terms of unintended consequences, is impact to our resources. And we are, cyanobacteria has been a perennial issue in the legislature the last few years, and we're all concerned about the water quality of our lakes and rivers. And we've all started to see the cost to do remediation or even to do prevention. And Senator Waters, you've certainly seen the issues around nutrients in Great Bay. The case that was brought up in Waterville Valley earlier today, I should say, was a kind of specific case because the waters of the White Mountain National Forest are considered a sensitive resource, and they receive some extra treatment. And so that's one of the reasons why the cost of that project was higher than your average cost. And that's the same protections that are around some of our Class A drinking water supplies and our designated rivers. So there's certain areas of the state and Great Bay as well where there's a need for the increased cost. And this is in essence how we're implementing the policy of trying to hold the load and not increase problems in areas that are either experiencing problems or we want to maintain as pristine. So the last point I'll make is regarding the value of the DES review. In the last year look back, we found that about 80% of our applications needed some sort of improvement. And we're not looking for problems, but we're finding them. And I'm quite sure that the quality of work of the colleagues in the room today is excellent. But in general, we are finding applications that are not complete, or they're expecting the department to do the peer review because there's not the ability to do it in-house. So there's a real challenge for us in the staff time required for that. In some cases, we are trying to get to yes on these projects, and sometimes it requires us to go back and forth 5 times, not because we want to, but we're trying to get to yes for the applicant and help them to get something that's approvable. So in closing, the department is well aware of the governor's priority to speed up permitting, and we're on board with that. We will do what's necessary to achieve that goal. We do think there's a number of different proposals that are being put out there in this legislative session to achieve that, and we would recommend on this bill that we wait to hear some of those others and just make sure that we are working in a coordinated fashion once they all are out. Thank you, and we'll take your questions.
Senator Waters?
Yeah, I would. Anybody else? Your last point there, I really hear you. I think we've got a lot of moving parts here. I think we're all going to be supportive of the governor's initiatives. But it's just going to be tough for us, I think, to see how they fit together and, make a bad joke. We don't want to throw the baby out with the stormwater, and that there's some important regulations here. But the question I would ask is that you heard my earlier question about, whether or not it would be possible to have a kind of a process, if we did go to the 200,000, but have guardrails by which DES could rightly, in a given project, say, well, no, on this one, we need to talk about this. I know, this is a kind of local example, but in Dover, there's a process whereby the planning and zoning boards get together and work with a developer before any projects are brought forward and any plans and so on, so that they can have conversations about what might be likely to create this issue and rightly that. So by the time something comes in, there's a lot of that's been worked out. And, I know the care by which the department takes it, but I think it might be helpful to us if you look at these bills, and this one about that, the numbers of the 100, 200,000, and find find a way to help us out, to say, you know, we probably could go to 200,000 in certain, or you talked about, you know, the 10-year look back. You know, well, if there are some things to do about that, you know, let's have some language, because I think there's going to be a desire to try to do some things around this, but we want to do it the right way that'll work with the appropriate environmental controls. So that's not really a question, but I think that's where, you know, I think I know where we're going to end up on some of this. And that it would be helpful to make sure we get it right.
Senator McCarthy?
Thank you, Mr. Chairman. Mr. Sturbridge, always great to be with you. A couple thoughts here. We heard from one of the largest engineering firms in the state. We've heard from a smaller engineering firm that's talking about topography and so forth, not having the availability of town sewer and so forth, much larger lot size. So that a small project becomes this becomes a burden with a very large number, that roads, stormwater are going to be discussed and going. I would suggest that there are very few towns in this state with regional planning commissions and so forth that aren't already looking at this. I have concerns with cyanobacteria. Cyanobacteria isn't happening from great distances from water bodies. So you want guardrails, you can have guardrails with that. But I'm concerned with the threshold the way it is right now, that you're prohibiting small developers from even getting in to start those projects, which we need housing. We need housing dramatically. So, and I just want to raise another point. If we take away some of those items, if the governor gets to the position that the department is able to cut time frames, which I think we all think would be a great idea, we will get more housing out there. And the simplest thing, because I'm a simple man, is the moving from, I originally thought 200,000 was a great start. I was saying, why not 250,000? But when I do the numbers, the 200,000 is 4.6 acres. It's not 5 acres. And I'm set back just a little with the quick scenario that we're going to 5 acres, and I just make that point.
Seeing no further questions, thank you very much for your testimony.
Yes. Thank you very much.
Robert Johnson, is it Robert Johnson?
Yeah.
You don't play guitar, do you?
Place farm.
No, Mr. Chair, you wouldn't want to hear me play the guitar.
The singing is fantastic.
Oh, yeah.
Or sing. For the record, Rob Johnson, representing the New Hampshire Farm Bureau as the Federation's policy director. Farm Bureau is a federation made up of New Hampshire's 10 county Farm Bureau organizations, consisting of just under 2,500 family farms, supporters, and associated businesses. And we are coming from this in a different angle than what you've previously heard in this bill, that we are in support. In my tenure with Farm Bureau, which is closing in on 25 years now, there have probably been a handful at most, 3, 4, 5 situations where this legislation would have been of help, where it's been a small farm operation that is looking at either establishing a farm or expanding their operation and has met the threshold. And where the fee in particular is it's a burden, a significant expense in those situations. To give some detail to, I remember the most recent situation I'm aware of is we had a small farm operation that was removing topsoil and leveling for their operation, and they moved the topsoil to another area of their property, and they didn't understand that the area where they had moved the topsoil to, though they hadn't done any work under that, then all that is included, encompassed in the what is now my math says 2.3 acres. It's easier for me to understand that way than the footage. But so like I said, there are those. Though it's not many situations where it's we've been affected. To those individuals, it's very significant. And with that in closing, I'll say in our situations, I know that the agency has been, from what I understand, quite reasonable and worked with our members, but there's a good bit of heartache that goes along with it all. And I'll close with that, and thank you for your attention.
Questions from the committee? Seeing none. Mr. Mayberry, did you want to speak at all?
Yes, sir, I'll get some more data, but thank you, Chairman.
Yep.
For the opportunity, thank you.
I have nobody else. Anybody else want to talk about this? Going once, and twice, so. All right, I'm going to close the hearing on this. Pass that out. I think there's only one bill at 106 that you potentially could exec if you're.
I'll move to an executive session.
Second.
All in favor?
Aye.
Aye. Any opposed? Seeing none. Is there a motion on SB 106?
I'll move on to pass for purpose of conversation.
Any discussion?
So where are we at?
On 106.
Yeah. I mean, I saw we had all these concerns from folks, and then it looked like Tim.
I believe there's an amendment.
Yeah, I mean, so does the amendment really get at what, the PUC and I think it does.
So do you want to move the amendment?
Yeah, why don't I move the amendment? That's what we're talking about.
What's the amendment number? I had it.
Excuse me, 232S, 232.
Senator Waters moves 232S. And.
Maybe, did you have?
232S, yes.
You got it, all right, I somehow got two here. All right.
I'll take, yeah, you have an extra?
Yeah, you betcha. Only cost you a quarter.
Yeah, so the change is basically on line 10.
Yeah, so we're going, we're going behind the meter. And let's see what else we got. Let me get back to the original here.
I think it's changes to 100 kilowatt and 1 megawatt too, if I'm not mistaken, but I didn't find that in the bill. I thought that's what it did. Section 3 should be.
The other issue, yeah, and then the issue around the 20 years, which is important.
Yeah, there it is.
Right,
Yeah,
up
It's
to-
section 4 now.
Yep.
Yeah.
So that's all, that's changed?
Yes, it fixes the 100 kilowatt to 1 megawatt.
Up to 5.
Yeah, well, it was 100 kilowatt up to 5, and now we moved it to 1 megawatt up to 5. That's line 9 of page 2.
Yeah, gotcha, okay. So let's just take a look at the paragraph 2 here, because this is the PUC. It's some. Yeah, it's now paragraph 3.
So those were the only 2 objections.
Yeah, let me read through to make sure that. I think that maybe it's the same.
Senator Waters, I think the only changes are.
Yeah, okay, I think,
1
okay,
megawatt
so,
and then
all right.
putting that in
So we're gonna, I mean, I think the 20-year, what this does for the 20 years is important. And the PUC may not be real happy with that, but I do think that's one of the points of the bill.
Yeah.
And that's what Clean Energy New Hampshire pointed out, that it'd be very hard to do the contracting and the financing of these things without that assurance. And so it looks like with the behind the meter and the 1 megawatt, I think
up to 5.
I think it's fixed.
I think we've addressed the credible.
Yeah.
I think we've addressed the credible concerns that were raised during the hearing, yes.
Yeah.
Senator.
My notes indicate there was a question at the bottom of page 1 about the look-back period. And I can't figure out if the amendment addresses.
But the look-back period?
Yeah, that in-service dates after January 1st, 2023.
Okay. David, you want to
And
take
I
that?
can't tell if the amendment addresses that concern.
So the amendment, I don't know that it addresses it specifically. I'm trying to, no, let me just.
Maybe it just eliminates that?
It
Seems
eliminated
gone.
it.
Yeah.
And that was on the guidance of the Department of Energy, as I recall, that wasn't necessary to have in there.
Okay. So that problem's fixed.
Am I, Senator Waters, am I correct on that?
You're right.
That was my recollection of our conversation post-hearing.
Yeah, I think it's gone.
Yeah, I don't see it,
Yes.
Yeah, so I think that fixes
so it's
that.
fixed.
Yeah. Yeah, I think it's just gone. They took the date out and they changed it.
All right, so all in favor of the amendment to 0232S?
Aye.
Any opposed?
I'll move on to pass as amended.
Second.
Discussion? All in favor of, to move on to pass as amended?
Aye.
Any opposed?
Consent.
Second.
All in favor of consent?
Aye.
Any opposed? And who would like to take this out, Senator Waters?
Oh, sure, yeah.
Okay.
Not that I know what I'm talking about, but
All right.
if needed.
Senator Waters would like to take this one out.
Consent, so you won't have to.
Oh, right. That's right, unless somebody wants to take it off.
No, please no. I mean, well, Senator Lang may wish to talk about his great accomplishment. Who knows?
He can pull it off if he does.
I think really today that might be the best.
You don't want to move this one?
It's up to you guys if you want to.
Yes.
I know.
I'll move on to pass on 110, Senate Bill 110.
Second. All right, discussion. The one we
That's the one we just heard?
Yeah.
Oh, I think we ought to wait. I really do. You know, there's other bills coming in. This is not unrelated to the previous bill, so I don't see why there's a hurry.
Well, there's an FN on it, and so we have a time frame. This is gonna go to finance, and this may be a bill that we could push forward, you know, to sit on in finance if we chose to table it.
Wouldn't it be happier result to have some agreed upon language about the need, you know, the process for the 200,000? And there's also the bill is erroneous because it does not move to 200,000 feet, right? It just says there's no fee for that. So that, in fact, it doesn't accomplish what they do. And I can't vote for it like it is, and why not wait a couple weeks, I mean, I really would like DES to get us some language, and they've got, I mean, it's gotta be corrected in the first place. So I would be nice to have, on all these housing kinds of things, it'd be great to have an unanimity, and why not just give us a little time to fix it?
If you feel you'd be interested in working on amended language?
Oh, yeah, of course. I mean, that's why I was saying, you know, let us, we have a default to 200,000, but let the DES intervene if there's a particular thing about that site that means you're gonna have runoff into the, you know, cyanobacteria, nitrogen, or a gully in their neighbor's yard or something, you know, or running down the road. I mean, I don't think it's unreasonable. I think I'm convinced about the need to maybe be able to get to 200,000. But can we have some guardrails? That's all.
If I could. So I would be willing to wait if we clear up the point, because my understanding of this legislation is the threshold starts at 200,000 square feet. So if there's, if the understanding is presently that we're only just not charging a fee, but they're still going through the application, that doesn't make me happy. We need to have the threshold start at 200,000.
I think there's an error. I do think there's an error.
Okay. All right, so do we withdraw our
I'll
motions?
withdraw. I will.
I think we're gonna get something done, but
Fair argument.
I mean, why should, finance, can you imagine us trying to work on that in that committee?
No, it was more about
On the
buying some
policy
time
stuff?
for things to
Yeah,
sit back. I'm okay with that.
We'll get it done. We'll get something done.
I think that's the only thing that we have really ready for today then, so.
I would agree.
Is there a motion to move out of exec?
So move.
Second.
All in favor?
Aye.
Any opposed? Seeing none.
So, Kevin, you have a bill that's kind of pretty similar to what I'm doing, but yours is a better bill.
Thank you.
And I have to put your, this is always true. I'm up your best too, right? So I just don't know which one it is, but I'll find it. And
You want to use yours as a placeholder for something?
Yeah, I mean, we can, so we're both moving something over. I mean, you're moving,